I'm used to being behind the podium. I'm Kip Larnell. I teach here in the music department at George Washington University. I always have a mic in the room I'm in the basement of the music department, but I'm usually walking all over the place and can project loudly enough so that I don't particularly need a microphone. As I said, we have one more person who's supposed to be here this evening, but he is not, so we are going to go. We also had some requests to stream this live, which we have never done before for an arts presentation. So we are doing that. So unless Alex shows up, and he was going to be speaking, kind of representing the copyright efforts of ARSC. ARSC is the Association for Recorded Sound Collections. I've been a member of ARSC for probably about 20 years now. And ARSC is involved with all manner of sound recordings. You could be a 78 RPM record collector, you could be a sound engineer, you could be doing sound restoration, and be a member of ARSC. But I also know that we have some people who are not ARSC members who did not find out about this event through ARSC. And I'll also give you a little bit of background about how this all came about. Back in September, I pulled together a meeting of all of the archives in Washington, D.C. that had D.C. unique material. And that would include the University of the District of Columbia, which has a jazz archive. The Library of Congress, the Archive of Folk Culture, has lots of Washington, D.C. material. Smithsonian, as say in particular the Ralph Rinsler Archive. If you know that big mall event that goes on, the Festival of American Folklife starting at the end of June into early July. There have been a lot of Washington, D.C. artists there. University of Maryland has material in the District of Columbia Public Library. I think I've got all the suspects named there. And as we had a discussion about what do we have in our archives, what we'd like to do, for the collections, because we just started the DC Vernacular Music Archive and had the first event in the fall. And one of the things that came up time and again is the question of what can a nonprofit organization actually legally stream within its own borders, its own physical location, and not run into any legal trouble. And I'll give you an anecdote from a real-life experience at Cape Larnell from just last week. But I did want to, Jay Bruder reminded me that it would not be a bad idea to just remind folks, though everybody looks pretty friendly. I don't see anybody who's going to harass anybody, but ARSC does have an anti-harassment policy. And very quickly, the ARSC is committed to providing an environment free from harassment of any kind. We are dedicated to providing a harassment-free experience for everyone, regardless of gender, sexual orientation, disability, physical appearance, body size, race, or religion. So I just wanted to get that little disclaimer out of the way. And since Alex isn't here, one of the things that ARSC has been very involved with has been what we see as overly restrictive copyright laws for sound recordings. Now, sound recordings go into many different areas. It could be sound recordings on commercial recordings, sound recordings that have to do with interviews with people. Eric was just talking about sound recordings and film preservation. So, after the 1920s, those are linked in some ways. But I just wanted, I don't typically, in my classes, don't typically read things. I'm usually speaking to folks rather than reading it. But this is a resolution that was adopted in 2005 about ARSC and copyright. And so if you will bear with me, it's only a little over a page long. Sound recordings are a vital part of America's and the world's cultural heritage. Since the first examples were created more than 100 years ago, they have served as a reflection of cultural and social history, captured and preserved in a uniquely compelling manner. History speaks to us in its own voice through sound recordings. Whereas one of the principal purposes of the association is to, quote, foster recognition and use of sound recordings as sources for information by students and research scholars, end quote, as part of the ARSC bylaws. Whereas another purpose is to, quote, develop standards of bibliographic control and access to cooperating sound recording collections assembled for research or instructional purposes, end quote. And whereas another purpose is to, quote, foster improvement of techniques for the reproduction, sound preservation, storage, and preservation of sound recordings, again from the bylaws. The Association for Recorded Sound Collections finds that several provisions of the U.S. copyright law impede the effective preservation of historic recordings and unduly restrict public access to those recordings. The association recognizes the valid purpose of copyright in rewarding creators of recordings with temporary exclusive right to the exploitation of these recordings, thus encouraging them to create. However, the association believes strongly that neither creators nor the public are served by excessive long monopoly periods, especially those that exceed the period of commercial viability, or by restrictions on access to recordings that rights holders do not wish to exploit. The association believes that both state and federal copyright terms for sound recordings are excessively long. And you should be aware that in other places in the world, particularly Europe, the copyright on sound recordings is much more broad and liberal. Regarding preservation, the association believes that current copyright laws and regulations should be modified to eliminate many of the restrictions present in the law. For example, current law limits duplication to materials that are already damaged or deteriorating, which virtually assures sonically deficient archive copies, and limits archives to no more than 3 backup copies, which does not take into account the need for distributed copies, mirror sites, and backups in order to responsibly maintain digital repositories. There should be no legal barriers to the professional reformatting and preservations of published and unpublished historical recordings with copies of the best possible quality sustained in perpetuity so that humanity's oral heritage may remain accessible for study and enjoyment. Regarding dissemination, the association believes that copyright law should encourage and facilitate the widest possible dissemination of out-of-print recordings, whether by physical reissues or using modern technology, internet availability, or other means. Almost done here. The association is concerned about the large number of older recordings originally produced for commercial purposes that are now virtually inaccessible, or I might add parenthetically, overly controlled due to current laws. The association notes that hundreds of thousands of historical recordings are controlled by rights holders who have shown little commitment to the preservation and dissemination of these recordings. The association believes that when rights holders choose not to make historical recordings accessible or unknown, institutions and individuals should be permitted and encouraged to make these recordings available on reasonable terms and without undue risk or encumbrance. The association believes that facilitating dissemination would serve to foster appreciation of recorded cultural heritage by making recordings generally available for study, as well as increase the likelihood of survival of sounds embodied in these recordings. The association strongly urges that these concerns be taken into consideration in copyright legislation. And to that end, since 2005, there's been a committee at ours that has been looking at changing some of these copyright laws. I must say, as somebody who's done a fair number of reissues of sound recordings over the last 30 or 40 years, there have been times when I've wanted to reissue material long out of print and not particularly valued by Sony, BMG, and other companies, and trying to do that in a legal way proves to be almost impossible. This would be obscure material from 1920s or 30s. We're not talking about pop material of any sort, even if it's from the 20s or 30s, but hillbilly blues, gospel recordings that have a lot of, I think, historical and musical value, but I think relatively, at this point at least, in the 21st century, little commercial value. And as somebody who's published books and other sound recordings, I'm also concerned as somebody who teaches at a university that I always tell my students I don't download things just because I'm old and don't care to download things. But most of the students now use some sort of service, and we have children who are in their 20s, and they now use streaming. They don't download, they stream through Pandora and other what they call radio stations, which is an interesting term. But over the years, you've seen a number of downloading sites come and go in this country and elsewhere. And I know if one of the books I've written 3 or 4 textbooks, if some of those were pirated and I wasn't getting money for things that were being used, I would not be particularly happy. Now, things, again, that have gone out of copyright or being held by restrictive copyright is a whole other matter. To bring Eric into this conversation some, and to bring this into my example from last week, I live in Silver Spring, and I went to downtown Silver Spring to see a documentary film, and the film was on the alleged possible appearance of Led Zeppelin at the Wheaton Recreation Center in 1969. So it was on that topic, plus other related things to American popular music in the late 60s and early 1970s. The film has not been commercially released, and it includes popular music and rock recordings from that time period. But the reason I mention this is, so we're sitting there, it's 7 o'clock, and this was going to start at 7, and so we waited around a little bit. As we were waiting, the folks there got up, let me see, which one was it? I think it was Pandora, put Pandora on the screen and started to stream classic rock. And so the first thing I thought about is, by Monday, I'm going to know so much more about whether this is legal or not, because here we are in a nonprofit institution. This is the community center in downtown Silver Spring, at an event that's not making any money, but is streaming from Pandora. I was thinking, is this legal or is this not legal? I really have no idea. So that was kind of my introduction to Eric about this whole topic. What we thought we would do is, I have probably a few other things to say. I know Eric has some things to say. He did not realize we just set this up for streaming. I made several requests, and ours has never done a streaming program like this. But the folks who run Air Show said, "You can stream this?" And I said, "I don't know. We've never thought about doing that." He said, I can't be there. I would like to see it, and I know the folks in Denver, because they now have it. Dave Glasser's now in Denver. They would like to see this as well. So before I go any further, how many people found out about this? I'm just curious, through the Ars Blisk, probably a minority of folks. What other avenues did people, what other lists did this get on that folks heard about it from?
AES.
Okay, so the engineering. Okay, any other? I see some folks who might just be college students.
We're in an undergraduate media law class, and this was passed out by our professor.
Okay, okay. One of the things that Eric said is, if this is being streamed, I have to be a bit more reticent and circumspect. So I think what we're going to do is we're going to be doing some talking, and then hopefully people have questions, because part of what we wanted to do was that people from the DC Public Library or any other nonprofit museum, wherever it might be, ask very specific questions that it may come up. So I think we're going to be doing streaming as we present, and then if people have questions, then I think Eric will feel a little bit more comfortable about kind of speaking off the record about some more direct questions that at this point probably should go unanswered. So it surprised me a little bit that you said, "Oh, if I knew, now that I know this is streaming, I kind of have to change my presentation," which I didn't even think about. This is very last minute. So to answer my question, if you wouldn't mind, so we're in this nonprofit, we have Pandora up there, we're streaming Pandora. The easy question is, or maybe not so easy, is legal or not legal?
I do. I don't know what their license is. So, do you want
No, that's a good
start?
question. Yeah,
Okay.
go ahead.
Okay, so, all right, couple things, and not to be mysterious about the streaming. I just found out as we were sitting here that I'm streaming live, and only on Friday for sure that I was presenting, so I'm really not sure exactly what you want. So on the streaming part, not to be mysterious, when you're a lawyer and you represent clients, I have no idea who's asking a question and whether it's someone who may be adverse to a client. So it just sort of changes the dynamic of the way you answer questions, right? Give you the answer to the question, and I represent Pandora. I don't. That would be a different answer to the question than if I don't. So that's not being mysterious. And while I take the harassment policy very seriously, I assumed that mostly it was expecting it would be directed at the copyright lawyer in the room. So that's my first question to you, because I'm just gonna, not to use a sports metaphor, but to use a sports metaphor, change this on the fly here, and call a play at the line. How many lawyers are in the room? Show of hands. How many people would say they have some familiarity with copyright law? How many would say they have a lot of familiarity with copyright law? That was a one shaking a hand up, down. Okay, why don't I, if you don't mind, why don't I just do a quick, just sure, 5 minute or something primer, so then the questions will kind of have context, and then I will answer your question. All right. First, my background. April 1, 1988. It's an easy date to remember. I came to the Copyright Office and started a career as a copyright lawyer. So I've been a copyright lawyer for, do the math, 27 years and a week, or not quite a week. I have also equal amount of time once I got to the Copyright Office in the Library of Congress doing work first on film preservation issues. Why? Because my first assignment at the Copyright Office was to do a study on the colorization of motion pictures and the moral rights issues. And the thing that struck me first and foremost as someone who knew nothing about anything, including copyright, was that there was a lot of discussion about the changes being made to film post-theatrical use, but no discussion about the preservation of the underlying material in a film form. To colorize films, you had to do a transfer on a telecine and then colorize it on a computer. And I remember the first question I asked folks while doing this study was, what's happening to the film? I mean, you're worrying about the rights, or the directors and screenwriters and cinematographers have the rights of producers, but if the film doesn't exist in 20 or 30 or 40 years, who cares? Maybe they'd still care, but for the rest of us, who cares? And so I actually wrote, we were given a 1-year assignment to write this study. A bit ridiculous. And even more fun, put on a plane and off I went back and forth to Los Angeles on a number of trips and spent time with Sidney Pollack and the directors and other directors and cinematographers and so on. And it was a lot of fun, a little bit of film school for me. But I also met a lot of archivists and learned a lot about preservation and helped in the startup of the Film Preservation Board in '88 and then starting the National Film Preservation Foundation in 1997, which I started here in DC in my law office. And then simultaneously, the Film Board was set up in '88 as kind of a response to that colorization issue. Not sort of, it was. The idea being that you couldn't colorize films if they were selected to a national registry by a board of advisors to the Librarian of Congress. And for 3 years, titles would be selected and they couldn't be colorized or otherwise materially altered. And it wasn't the greatest idea to do that necessarily, but the idea that formed was a group of people who started worrying about the underlying material, the film, and the preservation of it. And that board still exists as an advisory group to the Librarian of Congress. We did the first, I remember asking in '89 or '90 as the non-preservationist on the group, I don't even understand preservation. What if we just did a national study and took a snapshot of the problem and brought everyone in the room who had an interest in the issue? And so was born the National Film Preservation Study of 1992. And then having worked on Capitol Hill before I came to the Copyright Office and knowing that studies are things that you do in Washington to let issues die, what would happen if after that we created a national plan to address a way to go after these issues? And so was born the National Film Preservation Plan of 1994. And one of the issues that was at the sort of fore of that national plan was the films that were most in need of attention and preservation were orphan materials, non-commercial materials. Because anything that has a commercial underpinning, actually copyright law helps in some instances to keep that material both preserved and make it accessible because there's a financial incentive to do that. And in 2000, NARIS, the Recording Academy, took the film preservation language that we had written in 1992 and globally replaced, in Word, the words sound recording, replacing film, except in 2 instances where apparently they forgot to replace it, and gave it to Congress, and they passed the National Recording Preservation Act and created a board, and we've been trying for the last several years to get the foundation going as well on that. Okay, none of this has anything to do with copyright except to say I've spent an equal amount of time, just about, certainly with film preservation. I'm a lot less knowledgeable than all of you in the room on recorded sound preservation, but I've had some exposure because I've been on the recording board since 2004 as well. So anyway, that's my background. So that's why I sort of have the dual background. And I work with archives, never paying, and help educational institutions and historical societies and others with their collections. All right. A couple things for those of you who don't know copyright law. It's archival rule number 1. Rights in the physical material are completely separate from the underlying intangible property right in copyright. The fact that your institution owns the collection means you own the physical collection. Unless any rights transferred with it, you own none of the rights in it other than the right to have the collection, hold it in your hands and enjoy it. But when it comes to copyright, the 5 exclusive rights of copyright: reproduction, distribution, adaptation, public display, public performance, you need to go back to the rights holders to be able to do those things. Now, if you're engaging in non-public performance or display, or if you're doing something that's deemed an exception to those 5 exclusive rights, then you can undertake those activities in the institution. Okay? So there's the and looking at copyright law from the point of view of a user may be sort of the wrong end of the telescope. Here's why. I've always drawn copyright law, when I started this 27 years ago, as a triangle. Top of the pyramid is an author, the person who creates. And then in the 2 corners of the pyramid, you have, one is the publishers and producers. Some of them pay for the author to create. And then you have users. And it used to be that users was this sort of broad combination of users on a hierarchy. The hierarchy of users, the higher user, was probably your library and archive. And the Copyright Law of '76 Act understood that when in Section 108 it created an entire section for the use of materials by public libraries and archives. Note the word public. It has to be open to the public. And it was thought, well, it was written in '76, so it was brick and mortar libraries and archival institutions, right? And then you had all the other users. Why the hierarchy of users? Because libraries and archives collect material, preserve material, catalog material, spend oftentimes public and sometimes private monies doing this, and then make it accessible to a much wider audience of users. So the law at least was giving them that benefit. Okay, why authors at the top of the pyramid? Because for those of you who aren't lawyers but may know something of the Constitution, copyright law is found in the Constitution, Article 1, Paragraph 8, right? If you know your constitutional law, Article 1 is the enumerated powers of Congress. 2 is of the executive branch, and 3 is the judiciary. Article 1 rights say that Congress shall, and the Congress shall in Article 1, Paragraph 8 says that Congress shall pass these laws, and the grant is to authors, not users, for the progress of science, from the Latin scienter, knowledge. So you give something to the author, you give them a limited monopoly. Why limited? Because people can make use of their material even during the term of copyright, fair use, library and archival exceptions, and a whole host of other exceptions. And copyright doesn't protect ideas, processes, methods, so there are some things that copyright doesn't protect at all. And the First Amendment protections, what the Supreme Court has called the First Amendment accommodations, are found in those exceptions. So the notions, whenever you hear folks in legal arguments making First Amendment right to use this material. Note, first of all, this isn't your speech, it's the speech of someone else, known as the author. They created it. You're taking their speech. You have the right to comment, criticize, and make some limited use of it. That's fair use. But it's the speech of someone else, okay? So at least that used to be my triangle of how copyright used to look. And then came the internet, and it is a flat lining. And I don't mean dead, it's just flat lining. In one side, when you hear this in blogs and everywhere else, are content producers. And I hate the term, but it is what it is. The term, and it just lumps everyone together. Whether you're making Transformers 19 or you're writing the great American novel, you're a content producer, right? And it's all in the same bag. Individual, juridical entity, doesn't matter. And then on the other side are users, and what's changed, of course, is users are also in one bag, and mostly it's thought of the internet user, I want it now, I want it for free, and I want it in every format, more or less, from some point of view. And I don't mean to slight or to denigrate the point of view, but that's sort of the way it is. And what that's sort of taken away is the nuances of both the law, the way the law is supposed to have worked, the fact that, and then everything got personal, like everything else in Washington. And one of the fears for even, having a conversation in a room with 30 really nice people is the gotcha moments of, you said this, does that mean that, or you advise this, and and all of that stuff. And it's unfortunate. And the likelihood of change in copyright law, is unfortunately getting, dimmer and dimmer as the time passes. So the basics of copyright law, just rule number 1, physical property separate from the intangible rights. Rule 2 is that the rights holder has 5 intangible rights of reproduction, reproduction to make copy, distribution to move that copy from point A to point B, adaptation, so to adapt the work, publicly display the work. Think of that more in the visual arts, museums displaying paintings, 2- or 3-dimensional works of art, and public performance. Well, everything on the internet is now, what everything used to be was reproduction right? It was making copies, selling copies, even downloading copies. Nobody downloads music anymore. Everyone just wants to stream it. So the public performance right is sort of the king now. The other thing that's changed, of course, is that everything used to be push in copyright, right? The rights holder, you're the author, you write the book, you're the publisher, you're the film studio, you make the movie, and then you put it in the theater on such and such a date. And it was a push to the users. And now everything is pull, where everything is interactive. And you just put it in a place, make it available, and then the user decides, I want this now, I want that now, whether it's in Netflix to watch film, whether it's on the streaming services or anything else. And that's changed the dynamic too, because you have a system, for instance, in music that grew up where all the rights were very clearly delineated to some degree, and then different organizations collected for different types of uses. The Harry Fox organization collected for mechanicals, reproduction. ASCAP and BMI are only performing rights organizations, so only for public performances and only for non-dramatic works, so not for opera, right, but for the non-dramatic music works in public places. And so when you have a world also in which the rights are not so clear, when something is occurring, is it a reproduction, is it a distribution, is it a public performance, and often the answer is yes. It's very hard to understand how to clear rights, to whom you have to go to clear those rights, or to buy or to license rights from, or where there are exceptions, whether the exceptions even apply to those activities. Because the exceptions were also built into the law to apply specifically to only these acts of reproduction, only these acts of distribution, only these activities of public performance. Example. Here's the structure of copyright law. Section 106 are the 5 exclusive rights. First of all, let me back up. Copyright law, because it's in the Constitution, is all federal law. Okay, so and we'll talk about pre-72 sound recordings. So whenever a lawyer talks, they always say, but there are exceptions. So that's my exception. Put a pin in it. We'll come back. But it's federal law, which means Congress has to pass it. Which means Congress last passed major reform of the Copyright Act in 1976. In force January 1, 1978, because they gave themselves about 14 months. Jimmy Carter signs it in October 76, and it goes in the law January 1, 78 to give them transition time. The law before that was signed in March of 1909 by Teddy Roosevelt. Little trivia question, because it was in March and presidents change term in March, not January, all right? But that law, and you hear how antiquated the laws are, and it never keeps up with time. Think 1909 to 76. Dawn of the recording industry, television, computer, satellite, cable. Somehow the law, not ideally, but was flexible enough to allow for a motion picture industry, and commercial motion picture industry. Was able to sort of flexibly and in 30 some odd pages to very adeptly cover all those activities. 76 Act took 21 years to enact. 11 of those years, the whole, was a dispute between the cable industry, so distributors, and the motion picture producers on the retransmission of cable issues. And that was about 10 or 11 years of the dispute there. So what hasn't changed today? Where are the copyright disputes today? Between the distributors, right? YouTube, Pandora, Sirius, and others, and rights holders. So what's changed? Not so much. The technology changes, but the stuff remains the same. So that's my nutshell of copyright law. The exclusive rights, the exceptions. The only thing to add on to the 76 law was the fact that when it came to enforcement, just having those rights of reproduction, distribution, and so forth weren't enough for rights holders, because you now had technological protection measures that were being used, electronic devices, to insert. When I draw this for my law students at Georgetown, I put a dot on a board and I draw a ring around it and said, there, that's my DMCA illustration. You can use it. It's not copyright protected. The dot is the copyrighted work. Surrounding it is some electronic barrier, which is a technical protection measure. It's either a password or it's something that prevents the copying of the work. And the breaking of that outside barrier was felt by rights holders as something they needed to protect themselves, because once you broke through that and once the work was out on the internet, enforcement was over and done. And then the ISPs and others who were distributing materials said they didn't want to have obligations on their own, so-called third-party liability, where they could be liable for copyright infringement that their users were undertaking. And thus, 2-3 years of debate was the DMCA. That about is the most simplified summary of the DMCA I've probably ever done, but it gives you a sense of that. Okay, so here's structure of the law, and I do answer the question. 106, 5 exclusive rights. 107 is fair use. Okay, so that applies to everyone in terms of fair use, and it sets out 4 factors. What happened was, in the 76 Act, you had case law developing fair use, and it was always very fact specific. So Congress took essentially 100+ years of case law and reduced it, pretty nifty reduction, to about 2 or 3 paragraphs, and said, here are at least 4 factors that should be considered for whether a particular use is fair or not. And they gave some illustrative examples, and it says, such as, that means these are examples, not limited to, in the cases of criticism, comment, scholarship, news reporting, as the examples, then you can, under these 4 factors, with no mathematical formulation, in some instances, make use of materials. And in most cases, until recently, the application was to portions of works, not to whole works. There were some examples that were given, and one in the House report, interestingly, was a preservation example, which said this is fair use, which was the copying of nitrate film to acetate film, which is known as preservation in the film preservation world. That's when you preserve a film in the film archival world, you transfer it from an unstable medium to a stable medium. When you then clean it up, add scenes, and, that's a restoration, different term. But the House report explicitly referred to preservation as one of those fair uses of a use of an entire work being a fair use. And by implication, that means in most other instances, the use of an entire work is probably not fair. And then you had the exceptions, 108, libraries, public libraries and archives, and gave very specific examples, some for purposes of preservation, some for purposes of published works and unpublished works. Why the difference? Because if you're the author and you have an unpublished manuscript, at least the fair use cases have always said you have more rights in the work, not less, in terms of someone else using the work, because you haven't divulged the work to the public. Your work, you're the author. Again, top of the pyramid. You think of copyright law and the constitutional underpinning of it as giving the author the rights to do that. And then published work, well, you've now made it publicly available, then the taking can generally be more than of the unpublished material. So that's 108. And then 109 was the first sale, so the distribution right exceptions. 110, public performance right exceptions. 111, cable, that thing that held up the act for 11 years, and so forth, through 122. And I'd allow you from my memory to go through them all, but you don't care, nor do I for the others, but that gives you just sort of the example that Congress giveth, 106, to the author, and then from 107 to 122, it taketh away. Okay? So how then can any archive, can any educational institution make sense of, for instance, fair use? Fair use is always determined on a case-by-case basis, and every court always says that. We need to know the facts. So if you ever hear someone telling you that it's fair use, I've heard the 1 minute rule for years. The 1 minute, whatever the 1 minute rule is in film or music, there is no 1 minute rule. Of the 4 factors of fair use, one of them is the purpose and character of the use. So how much does the user transform the use? And in a way, that's really become very important for courts, because they say, well, the user is actually doing something of value by transforming the original work into something that has some social benefit. And so the transformative use, the purpose and character, is important. Second is the nature of the copyrighted work. It's generally not a critical factor, but it just weighs in. And is it published or is it unpublished? It's just sort of an on-off switch. Third is the amount and substantiality of the taking. And here is where the 1 minute rule couldn't apply. If you took 1 minute of a 1 minute film, you've just taken 100%. Or a 1 minute recording, you've taken 100%. So it's the amount and substantiality from the original work. And I do a lot of documentary film production work now. And I can tell you that the film director producers always get this wrong, because they say, I've only taken 2 minutes and my film is 2 hours long. Who cares how long your film is? The 2 minutes that you took was from how long of a film? 5 minute film, you've taken 2/5. So the amount and by the way, it's qualitative and quantitative. So you take the most important line from a film that you've taken the qualitative but not quantitative taking. And the fourth is the effect on the rights holder's potential market. And potential matters because, for instance, in the Napster case, Napster and others were arguing these guys aren't in the digital market. And the court said, yeah, that's because you've polluted the market. They can't get there. Harm to the potential market, right? So it wasn't, if you're in a niche market, there might be something different, but certainly the movement into the digital realm was something else. And then you have your big fair use cases. And I won't go through them, but I'll just mention Betamax 5-4 decision. What's interesting is when you read the court's papers when Thurgood Marshall passed away, and he gave his papers to the Library of Congress, and they were made public, much to the chagrin of the rest of the court. You could read all of the internal memos of the court with many sitting justices and find out that Justice O'Connor had changed her view on the Betamax station, and it would have been 5-4 holding that even the time shifting of public television onto a DVD, a home recorder, for purposes of watching it later, would have been held not fair, and she changed her mind. And when you looked at the internal memos, one of the things that was important on that was because it was not what was referred to as library. It wasn't a retention of a copy. It was just you're going to watch it one time, and in fact, the harm to the potential market was if the show was being broadcast, as these were public television, public stations, the advertising pays for it, more people would watch it. That increases ad revenue, right? Because people who couldn't watch it, because you're stuck listening to a boring speaker on a Monday night, and you wish you were at home watching something more interesting, NCAAs or whatever it is, you could time shift it, go home, watch it. You would be part of that advertising, the number of eyeballs watching it. So I've always thought it interesting. Nor has personal use ever been equated with fair use, because if it were, everything we do is, personal use. Then you've got some of the mass digitization cases lately, Google Book, HathiTrust, and if you watch and read those cases, it's on the blogosphere, read the cases, you'll understand the very limited nature of what is and isn't deemed permissible by the courts in those cases. Of the use of the material, for instance, the HathiTrust case, which was decided only last June, fair use for research university libraries to make digital copies available for purposes of searching terms. This is data mining only, not to even allow snippets to be made available within online texts, and for the full text only for print-disabled patrons in the library, because they otherwise didn't have access to these materials. So the only ones that had full access to it were print-disabled, the VIPs, visually impaired persons. So that's your structure of the law. That's your exceptions. So the couple other things, just two worth mentioning. So the area that probably is the most aggravating for libraries and archivists and educational institutions and all is figuring out 108. And it is for copyright lawyers too. It was written in an analog world using words like facsimile copying. I'm sure you do a lot of that these days. And the idea to refresh it is not new. The Copyright Office undertook a study in 2008, reached agreement on a lot of changes that would have surely benefited public institutions making material available, and Congress never acted on it. And more recently, frankly, national library groups have decided that they oppose any copyright reform because they think they're doing better in case law. So repeat after me, because of fair use cases only and always are decided on a case-by-case basis. How does that help a librarian or an archivist working in an institution unless your facts are foursquare within the box of a particular case? It doesn't. It doesn't, and it's sort of a shame. And then the other area is orphan works legislation, to allow for the use by all users, some users, to make orphan work material more available, more accessible, and if rights hold, after doing a really good due diligence search to try to find the rights holder, and if you can't find it, then to allow certain uses of the material, and then if the rights holder does surface, to allow for some minimum payments, or some payments, to the rights holder. And that bill passed the, I always get this wrong, Senate, not the House, House, not the Senate, in 2007 or 8, and the Copyright Office, 2006, has refreshed the studies, and there too, it's just not anything that you necessarily see moving forward. So 2 years ago, Congress undertook a discussion after Maria Palente, the Register of Copyright, called for the next great Copyright Act, and she just threw out notions of potential changes to refresh copyright law to bring it into the 21st century, now 15 years old. Congress, the House Judiciary Committees held in 2021 hearings on subjects and what is likely to pass of this copyright reform. I'm not a betting person. I don't have brackets for tonight's, was not in the brackets for the games, did not do well. But if I were betting, I would say absolutely nothing. You have such strong feelings around the horn of copyright from rights holders and user groups, and don't ever assume that, rights holder film is, major film producer, documentary film producer, actor, director, screenwriter, music. You're talking large label, small label, independent label. I mean, there are just so many different players in this, and there's not unanimity between music publishers and labels, recording artists, featured artists, non-featured, that it's just not something that Congress can do or does well in terms of making tough decision making. Here, is the likely outcome of the hearings, possibly reforming the Copyright Office. When I stepped out of the Copyright Office in September of 1994, 20 years and 6 months ago, the thing I was working on was to create an electronic registration and recordation system for the purpose of rights holders and users. The recordation system is all the transfers and assignments, so you can know A authored the work, but now Z owns it, and you could see the chain of title from A to Z if it was recorded at the office, and to have an electronic system. Today, the Copyright Office records documents the way it did in 1890. It comes in, it gets keyed in, and by the way, if they spell Schwartz wrong, that's it, you're in the database, and try to find, that I authored it in my name, good luck, because it's just been entered in the database that way, and nothing is electronically scanned in that way. And registrations, yes, are now, 2007 went electronic, but try doing a search. Try doing a search. Go in the Copyright Office database. I gave this example to a friend who testified on the Hill, and he used it in his testimony. Type in the words "The Godfather." Now, in any ordinary database, or if you were on Google and were searching, number one, you would come Mario Puzo's novel from whatever year it was, 69, 70. 2, you would get Godfather 1, 2, 3, right? The film, and then you'd find all sorts of other things called The Godfather. Have fun, do a search, and see if you can find that in the Copyright Office's database. And those are the types of things that would just help the user community in the simplest way, and the Copyright Office has been hamstrung by the Library of Congress's IT system for so many years, built catalog books. They designed, the motion picture folks out at Culpeper designed their own cataloging system for motion pictures that doesn't even rely on the library's book system. So, you could see that happening, and that would be, I suppose, the good news. Okay, so about 40 minutes ago, I promised you to answer your question, and the answer is Pandora is playing in a public place. Okay, I don't know whether the public place has a license. Now, in a musical work, note that there are 2 copyrighted works. There's the underlying composition, right, music lyrics, that is the composer owns and then licenses to her music publisher to collect for her. And for public performances, licenses to ASCAP, BMI, or CSAC to do public performance licenses in public spaces. Does the enterprise have a public performance license? No. And on the streaming services, the recording copyright is held by first the performers, then through their agreement with their record label, is held by performer and or record label. And they have, remember I said you have 5 exclusive rights? Well, there's sort of 5.5. In the area of sound recordings, in the late 1990s, sort of the beginning of the discussion was, reproduced sound recordings have never had a public performance right. Why? Because broadcasters have long resisted the public performance right. They pay for the underlying composition, so Bruce Springsteen singing a Chuck Berry song on the radio, Chuck Berry as composer would get all the public performance royalties, Springsteen nothing in public performance royalties. If he sold records, great. Nobody's selling records, so public performance, remember what I said, is king now. So in the 1990s, Congress created a limited public performance right for digital works. And the way it works is basically threefold. 1, for regular analog broadcasts, no public performance right, status quo. 2, for completely interactive services, so where the users are pulling material, Congress created a full exclusive right. So the rights holders, the performers, and the labels get to control the use, and it has to be fully licensed. And then in the middle, they created this non-interactive streaming service. So for qualified non-interactive services that are just pushing music out, there is a statutory license that pays for each performance. This determined by the Copyright Royalty Board at a rate of 0.0000004 something 37 cents, which is what I used. You read about the artist who said, it's been streamed 1 million times and I got my $4. That's about right. And we've devalued the music industry and the public performance right, which is why here's the statistic from 2000 to today. The music industry, in terms of total jobs, is down over 50%. Now, we've lost in 15 years half of the paying music industry in jobs. It's down in jobs and it's down in revenue. The place that's making music is live venue music. And composers can make music from their public performance royalties in venues, but that's it. They're not making for downloads. No one's downloading, and performance royalties normally for streaming services, the rate is so low that it's just sort of hard to, have any acceptable income. So that's much more than you asked me. Again, I just sort of on the fly, a little bit of summary of the law. In a particular space and in a particular use, the way you answer your question is, what activity is taking place? Is it a reproduction, public performance, distribution? If so, which rights are we talking about? The underlying composition. It's not being reproduced, it's just being performed. So if there's an ASCAP or BMI license, yes. Well, first question is it a public performance? Absolutely, in the venue. Private is considered, among normal circle of friends and acquaintances. So, in any private social setting, that you have a private performance, you don't need a public performance license. Everything else you do. So you would need a public performance license for the underlying composition. So the one is yes, and then for the streaming service, it depends what the license for the streaming service is, and be able to put it just into individual homes or into public venues, and to have the license there. And that one is just I don't know the answer in the Pandora license. I should, but I don't. So how to proceed? Alex isn't here. I've now eaten his time and your time and everyone else's, and take questions that you have, or that's how you want. I stumped the copyright lawyer. This is always fun.
Now, do we want to turn off the streaming so you could be more candid?
I wouldn't mind it.
Okay, let's do that then.
With apologies to those who. The other thing that I didn't mention, but certainly worth mentioning. And so there's